In the spring of 1916, a man named Harlan Fiske Stone stayed up late in his personal study, reading a ruling just issued by an obscure federal circuit judge few had ever heard of. He went over it once, then twice more. Finally, he set the document on his desk, stared at the opposite wall, and uttered a remark his clerk would repeat for decades. He said, "If they allow this to hold, everything comes apart." They did not allow it to hold. Within weeks, the judge behind the opinion was stripped from the case. The ruling was suppressed. The attorney who had presented it for the plaintiff vanished from legal history without a trace. In that decision, the last time in American history that a federal judge formally declared the income tax unconstitutional on grounds entirely separate from the 16th Amendment, was quietly scribbled from the official records. What transpired in that 1916 courtroom is no minor footnote. It is the central thread. Yank it, and almost everything you believe about the financial scaffolding of the modern era starts to split at the seams. This is that account. If buried history like this is what you came for, hit subscribe right now. This channel ventures where textbooks fear to tread. New documentaries weekly. Ring the bell so you never miss what's next. To grasp what happened in 1916, you first need the world of 1909. That year, America had no permanent federal income tax. 2 prior attempts had been struck down by the Supreme Court. The first came in 1895 with Pollock v. Farmers Loan and Trust Company *. By a 5-4 vote, the court ruled that a direct levy on income from property, rents, dividends, interest was a direct tax under the Constitution, requiring apportionment by state population. Without apportionment, it was void. That ruling ignited fierce backlash. Critics called it the most destructive high court decision since Dred Scott *. But here's what rarely gets mentioned about Pollock *. The lawyer who persuaded 5 justices to kill the tax was Joseph Hodges Choate. During oral arguments, Choate made an extraordinary claim. The income tax wasn't just a levy. He said it was a philosophical declaration, the opening move in what he termed a communist assault on American property. The justices who sided with him weren't merely parsing the Constitution. They were defending an entire civilizational order. They believed the bond between a man and his earned wealth predated the Republic itself, something far older, as we'll revisit, possibly older than anyone suspects. By 1909, political pressure to revive the income tax was unstoppable. Progressivism surged. Teddy Roosevelt had finished 2 terms and agitated for economic reform. William Howard Taft occupied the White House, straining to keep the Republican Party intact while fending off populist rage. Congress drafted the 16th Amendment. The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Short, clean, devastating, but ratification hit a snag, and not a small one. The Standard Story says the 16th Amendment was ratified on February 3, 1913, when Secretary of State Philander Knox certified 38 states had approved it. In 1984, a tax researcher named William Benson spent 2 years visiting every state archive that supposedly ratified the amendment. He returned with something that rattled the few constitutional scholars paying attention: original documents. According to Benson's analysis, the ratification process was riddled with procedural errors, alterations, and outright fraud in several cases. States that rejected the amendment were counted as approving it. States that passed different wording were tallied as approving Congress's exact text. Kentucky ratified after certification, which legally meant nothing. Minnesota never even sent its ratification to the Secretary of State. Benson published his findings in a 2-volume work titled *, the law that never was asterisk. The federal government's response was swift, absolute, and telling. It didn't refute his evidence document by document. It didn't open archives to show the public where he'd erred. Instead, it prosecuted him for fraud and made it a federal crime to mail his research to anyone who might use it to challenge their tax liability. Ponder that. The government's reply to a man saying, "Show me my mistake," was to outlaw sharing his work. But we're jumping ahead, because before Benson, before the prosecutions, before the IRS, there was 1916 and the judge. His name was Virgil Prettyman. Until recently, finding any trace of him required digging through county court archives across 3 states. Prettyman was a federal district judge appointed by Woodrow Wilson in 1914. No firebrand, no populist. Colleagues called him methodical, careful, deeply versed in property and equity law. In early 1916, a case landed in his courtroom that seemed routine. A businessman, identified only as a plaintiff in a sealed equity proceeding or revealing detail, was contesting income tax assessed on earnings from a specific commercial activity. The particulars of that activity have been redacted from every publicly accessible version of the court record. But what remains unredacted is Prettyman's legal theory, because Prettyman didn't rule on the 16th Amendment at all. He went further back. Prettyman's decision, originally 61 pages, surviving only in partial transcripts held in private collections, opened with a question no federal judge had ever formally posed. What is income? Not what Congress says income is, not what the Supreme Court has ruled income is. The foundational question, what, in the deepest legal and philosophical sense, is income? His answer, derived from common law principles stretching through English equity, the Magna Carta, and precedents he called pre-colonial American commercial law, was this: income as a legal concept isn't merely a measurement of accretion. It's not just money in minus money out. Income, in its original legal meaning, measures the productivity of something already owned. It is the fruit of property, and the right to that fruit, not just to possess it, but to possess it free from sovereign intrusion, wasn't created by the Constitution. It predated the Constitution. It was, Prettyman wrote, of ancient inheritance, a phrase he used 3 times. He wasn't speaking metaphorically. Before proceeding, we need to pause on something most legal historians have glossed over. Prettyman's citation trail is odd, not just unusual, strange. To build his argument about pre-constitutional income rights, he cited 11 specific precedents. 7 were standard English common law cases. The other 4 were different. Those 4 referenced a body of law he called the Continental Commercial Codes, attributed to what he described as the unified administrative tradition of the pre-war Western settlements, pre-war. Not pre-Revolutionary War, not pre-Civil War, just pre-war, with no further specification. Scholars trying to locate these sources have failed to find them in any standard legal archive. One researcher, writing in a little-known 1987 Journal of Legal History noted that 2 of the 4 citations appeared to reference administrative codes from what he termed an organizational structure that does not correspond to any known colonial or territorial government in the historical record. He speculated no further, but the implication was clear. There are people in the alternative history community, and this channel doesn't reflexively dismiss them, who have long argued that America's legal architecture didn't emerge whole from the founders' minds. It was inherited, adapted, translated from an existing administrative framework already in place when the Republic formed. That framework is what researchers call the Tartarian legal inheritance. At its most rigorous, the Tartaria thesis is about administrative continuity. The institutional structures we inhabit, courts, property systems, tax regimes, municipal corporations didn't originate when we were told. They were pre-existing systems absorbed, rebranded, and presented to 19th century populations as new creations. And the people who built those new, seeming institutions knew exactly what they were doing. If that holds, and the evidentiary case is far stronger than you've been allowed to see, then Prettyman's citations make a different kind of sense. What if the pre-war Western settlements weren't vague references at all? What if he was precisely citing the administrative codes of a prior civilization whose property law had never been officially revoked, only buried? What if the income tax violated a framework of property rights so ancient that its origins were deliberately hidden from the governed? What if the entire modern tax apparatus wasn't an extension of American law, but a replacement of something older? Harlan Fiske Stone, reading that decision in his study in 1916, said, "If they let this stand, the whole thing unravels." He was right, but not for the reasons legal historians assume. Let's return to Judge Prettyman and what followed. His decision was issued in March 1916. Within 10 days, the Justice Department filed an emergency appeal. Within 3 weeks, the case was transferred out of Prettyman's court via a procedural move legal historians call unusual but not unprecedented. Within 6 weeks, Prettyman himself resigned from the federal bench. His resignation letter, held at the National Archives, gives no reason. He was 51, healthy, on the bench less than 2 years. He resigned, moved to a small town in Western Virginia, and never practiced law again. He died in 1931. His local obituary doesn't mention his judicial service. The clerk present when Stone read the decision was Edward Creel. In 1958, he gave one interview to a retired journalist named Marcus Hollins, who was writing a private memoir about the early federal income tax. That memoir was never published, but pages have circulated in the legal history underground for decades. In that interview, Creel said Stone read the entire decision, then called Creel in and read one passage aloud, the part about ancient inheritance and the continental commercial codes. Stone then set the document down and said, "If they let this stand, the whole thing unravels. The codes he's citing, if those hold, the tax isn't just unconstitutional. It's void. It was always void. There was never a legal basis for it that didn't depend on suppressing what came before." Creel was asked what came before meant. He said he didn't know. Stone never explained. He just handed Creel the document, told him to file it under seal, and walked out. That document has never appeared in any public archive. Now we need to discuss what the whole thing actually means. By 1916, the income tax was barely 3 years old, but it was already the financial backbone of something far larger. It was the mechanism that made the Federal Reserve System, created in December 1913, 10 months after the 16th Amendment was certified, financially viable as a permanent institution. Without a reliable stream of income tax revenue pledged as collateral, the Fed's ability to issue currency backed by government debt was fundamentally compromised. The income tax and the Federal Reserve weren't separate innovations. They were two components of a single system installed within 10 months of each other, designed to interlock. If the income tax was void from inception because it violated a pre-existing framework of property rights never legally extinguished, then the Fed's collateral basis was also void. And every dollar issued against that collateral was issued against nothing. That's what Stone meant by the whole thing unravels. He wasn't talking about a tax ruling. He was talking about the monetary system of the 20th century. Here, the Tartaria thesis becomes not a fringe curiosity, but a load-bearing element. Serious Tartarian researchers claim that the pre-reset civilizations administrative and financial systems weren't debt-based. They were abundance-based. The infrastructure, massive public buildings, free energy systems, global communication networks, wasn't financed through debt. It was financed through a different mechanism: public credit commons, civic endowment systems, or simply the old system. Economist Michael Hudson has spent decades arguing that debt-based finance isn't inevitable, it was imposed, and prior civilizations had different arrangements deliberately destroyed and forgotten. He doesn't use the word Tartaria, but what he describes, mapped against Prettyman's citations, fits with disturbing precision. The Continental Commercial Codes, per the researcher who analyzed them most closely, had three distinguishing features. First, property rights weren't alienable by taxation. The fruit of property belonged absolutely to the holder, not as a sovereign's grant, not as state privilege, but as an original pre-political right. Second, the codes explicitly forbade private debt instruments as general currency. Money was a public utility issued by civil authority accountable to the community, not a private corporation lending money into existence at interest. Third, and this stops you cold, the code stated that no subsequent legal framework could extinguish these rights without the explicit, informed, documented consent of every individual affected. Not majority, not legislature, every individual, which meant, in Prettyman's analysis, that no constitutional amendment could extinguish the property rights those codes described, because the people whose rights were being extinguished had never been told those rights existed. They'd been kept from knowing. The income tax wasn't just an unconstitutional levy. It was a theft conducted on a population deliberately kept ignorant of what was taken from them, ignorant not just of their legal rights, but of an entire prior civilization whose administrative framework contained those rights. If Prettyman was right, the income tax was void the same way a contract is void when one party conceals material information. The American people entered an arrangement without knowing what they gave up, without knowing that the thing being taken had been protected by a legal system far older than the one they thought they lived under. This is the argument, Stone said, if allowed to stand, would unravel everything, and it nearly did. Because Prettyman wasn't alone. A name appears twice in the surviving fragments of the 1916 case, Victor Rosewater. He wasn't a lawyer but a journalist, editor of the Omaha Bee *. According to his private correspondence at the Nebraska State Historical Society, he knew of Prettyman's decision before it was handed down. In a letter dated 2 weeks before issuance, Rosewater wrote a Washington colleague, "The judge in the Virginia district has found the thread. If his reasoning circulates, the entire newspaper establishment will turn on him within a week. The people who built 1913 will not let a circuit judge undo it." He was right about the timeline. He was right about the reaction. He was wrong about one thing. It wasn't newspapers that buried Prettyman's decision. By the time they might have covered it, the ruling was already sealed. The process happened from inside the legal apparatus, faster than the press could respond. Who made that happen? Anyone familiar with Federal Reserve history knows the name Paul Warburg. Warburg was the single most important architect of the Federal Reserve Act, the man who, at the secret Jekyll Island meeting in 1910, drafted the core provisions of America's central bank. He was a member of the Kuhn-Loeb banking family, whose operations reach back through 18th century German banking houses into the financial networks of the old continental trading cities, the same old continental trading cities where those commercial codes originated. This is where the Tartaria thesis stops being a theory about lost architecture and becomes a theory about living power, about families and institutions and the deliberate multi-generational management of what people are allowed to know about their own past and property. The Tartarian reset didn't just erase a civilization. It created a new story about the past to justify new arrangements in the present, what researchers call a legal vacuum. The prior law became invisible, and the new law presented itself as the only law that ever existed. Into that vacuum, debt-based currency, income taxation, and a central bank backed by government bonds were installed. The people living through that transition had no framework for understanding what had been replaced, because that thing had been generationally hidden. Prettyman found the thread not as a Tartarian researcher or conspiracy theorist, but as a lawyer who took the question, "What is income?" seriously enough to trace it all the way back. He found a body of law predating the Republic, a framework of human economic relations that had been functioning, documented, and suppressed for longer than U.S. history itself. His clerk, Edward Creel, was asked in that 1958 interview whether he ever understood the full implications of what Stone said that night. Creel said he'd spent 40 years thinking about it. The line that stayed with him wasn't "the whole thing unravels," that was the famous line. The line that stayed with him was what Stone said just before. Stone had stared at the 4 citations to the Continental Commercial Codes for a long time. Then he said quietly, to no one in particular, "These are real." He actually found them. These are real codes from a real system. And then, if they let this stand, the whole thing unravels. Not anger, not alarm, just the flat, still voice of a man who had seen something he couldn't unsee. Real codes from a real administrative system that had governed real people and real property, a system whose property law was incompatible with the income tax, the Fed, and the entire 20th century financial architecture. Erased so thoroughly that a federal judge working from fragments no one was supposed to examine was the first person in American legal history to formally cite it in a federal ruling. He was then removed from the bench, resigned from law entirely, and vanished as completely as the civilization whose codes he'd cited. What happened to those archives? The 4 anomalous citations reference specific volumes and page numbers. Researchers found they don't appear in the Library of Congress, Harvard Law Library, or any major U.S. legal archive. They do appear in fragmentary form in 2 places. First, the Law Library of the Athenaeum of Philadelphia, a private legal society with a closed collection of pre-revolutionary materials accessible only to members. Requests to examine it have been consistently denied since at least the 1970s. Second, a set of institutional archives in Europe, a charitable foundation based in Basel, Switzerland, whose mission is preserving pre-modern European administrative documents. The foundation was established in 1921. Its founding donors included members of the Warburg banking family, the same family whose most prominent American member had, 5 years earlier, orchestrated the removal of the only federal court decision that ever cited those documents. The archives containing evidence of what was lost are controlled by the heirs of the man who ensured the evidence would never be used again. This isn't a conspiracy theory. It's a documented chain of custody. The documents are in Basel, controlled by a foundation with ties to the Federal Reserve's founding family, and have been inaccessible to independent researchers for over a century. Let's return to the present. The story of 1916 didn't end there. Prettyman's legal theory went underground, passed from researcher to researcher through the legal history underground that exists whenever the official record becomes too obviously incomplete. It resurfaced in 1984 when William Benson published his work on ratification, fraud, different methodology, same conclusion. The tax had no valid legal basis. It resurfaced again in the 1990s when legal theorists examined the distinction between the United States as a constitutional republic and the United States as a federal municipal corporation. Not fringe material, academic journals drawing on the rarely discussed fact that the District of Columbia Organic Act of 1871 created a corporate entity legally distinct from the republic established by the Constitution. If the entity collecting the income tax is a private municipal corporation, then the legal basis for the tax isn't the 16th Amendment. It's a private contract whose validity depends on informed consent. Consent never obtained. Consent that couldn't be obtained because obtaining it would require disclosing what the arrangement was replacing. Same structure, same argument, different angle. And surfacing again now because the Tartarian research community has, over the past decade, assembled a case far more rigorous than critics acknowledge. Evidence of a prior civilization with significant administrative and technological sophistication is there. The architecture, the infrastructure, historical anomalies, suppression of alternatives. Research, institutional continuity between families who manage the transition and families who manage today's system. It's all there. What's been missing is the legal thread, the specific, documentable point where the prior civilization's administrative framework intersected with today's legal architecture. Prettyman found that thread in 1916. It led him somewhere he wasn't allowed to take a courtroom, but the thread remains. The codes still exist. The foundation in Basel still holds them. The chain of custody is documented. And the family controlling the archives is the same family that buried the ruling. Once you find a thread and understand what it connects, it's very hard to lose it again. Now you know what to look for. The income tax isn't just a constitutional question. The Federal Reserve isn't just a monetary question. The modern state's legal architecture isn't a natural evolution of human understanding of justice and property. It is a replacement, a deliberate, generationally maintained replacement of a system whose codes described a world where the fruit of your labor belonged absolutely to you, where currency was public utility, not a private debt instrument, where no subsequent legal framework could extinguish your rights without your informed consent. A world the people who built 1913 needed you to forget ever existed. Judge Prettyman found it. Stone knew what it meant. Warburg made sure it never saw a courtroom again. Then the judge resigned, moved to a small town in Western Virginia, and never spoke publicly about it for the remaining 15 years of his life. But his clerk remembered. A journalist named Hollins wrote it down. Pages of that unfinished memoir have circulated for 60 years among people who understand their meaning. And now you know the decision is real, the codes are real, the suppression is real, the family controlling the archives is real. The connection between those archives and the creation of the Federal Reserve is real. The only question left is what you do with a thread once you've found it. Historically, the people who pull it are removed from the rooms where it matters. Prettyman was removed. Benson was prosecuted. Researchers who tried to access the Athenaeum were declined. The system is very good at removing people from rooms. What it has never been good at in any era, in any civilization, including the ones it replaced, is keeping the thread from being found again, because the thread doesn't disappear when the person holding it is removed from the room. It was there before Prettyman. It is woven into the citations of a 61-page decision that only partially survives, into the private correspondence of a journalist who knew what was coming, into the sealed memoir of a clerk who spent 40 years thinking about one sentence spoken in a quiet study in 1916. These are real codes from a real system. Stone said it. Stone knew what it meant. And somewhere in a foundation archive in Basel, Switzerland, controlled by the heirs of the man who buried the ruling, the original volumes still sit on a shelf, waiting for the next judge willing to cite them, waiting for the next courtroom willing to hear it, waiting for the moment when enough people understand what was taken from them that concealment becomes impossible. We're not there yet, but we're closer than ever. And that's exactly why the story of Judge Prettyman and the decision Stone said would unravel everything is a story you were never supposed to hear. Now you've heard it. What you do with it is up to you. The video linked on screen now goes deeper into the Federal Reserve's founding documents and the Jekyll Island meeting, including a detail almost no one discusses about what Warburg's original draft contained that was removed before the final bill passed. Watch that next. It connects directly to everything you just heard. Subscribe if you haven't. Hit the bell. Share this with someone who asks the questions most people are afraid to ask. The record is incomplete by design, but it is not irrecoverable.